All right, it's January 26th, Tuesday, January 26th. If you're following along on the announcement that sort of maps out the semester, we are now in week 3, which means the assignments are to read chapters 3 and 4 with some exceptions. In chapter 3, don't read conflict of laws or commercial disputes with nations. Instead, we're going to focus on arbitration and litigation, specifically jurisdiction. And this lecture will be specifically about jurisdiction, which is this week's discussion board post. On Thursday, I will lecture over the information for the one-page response paper for this week, which will be about the commercial contracts for buying and selling abroad. And that's in chapter 4. But we're going to focus on jurisdiction, international litigation. In this lecture, this should be hopefully the shortest lecture that we've had so far, and then that will enable you to just go ahead and do your discussion board posts so far this week. Also remember, tomorrow is Wednesday, so your one-page response and your discussion board from last week will both be due. Okay? Other housekeeping matters. Again, if you don't have the book, let me know. I'm operating now under the assumption that everyone has the book. No one has told me they don't. Other issues, did have a couple of issues in the first one-page response paper with some copy and pasting of content. Whether it's intentional plagiarism or accidental, always need to cite when you're referring to someone else's words, right? Which I don't really have a problem with that as long as it helps you answer the question and process the information. But the general intent is for these response papers to be your own thoughts, your own ideas. So try and avoid copy and pasting information from other sources, and especially when you do that, don't act as if those words are your own, because while I might be lenient about that in the first response paper, now that I'm reminding you of it, now that I'm mentioning it, I'm not going to be as lenient in the future. So just be very careful. Same thing with your discussion board posts. This is all intended to be your own creative thought as a result of your reading and as a result of watching the lectures. What I would suggest is that when you read the prompt, whether it's for a response paper or for a discussion board post, that you just think about the information and create a little bit of an outline, the things that you need to discuss in order to appropriately answer the question. Think about it almost as if it were a task assigned by your employer, right? You would want to walk them through the steps, your own analysis of what you think about the situation and what types of things you think would need further research or looking into. Sort of guide the person reading your answer, me, through your thought processes, what you're thinking and why you're thinking them, kind of the way you would show your work in a math problem. Okay. So I look forward to your responses from week 2, and I'll go ahead and jump into the information for week 3. We're talking about in chapter 3 litigation. There's a bunch of information in here on arbitration, and of course, if you are doing business internationally, you're of course going to be signing contracts for the nature of that business relationship. So very commonly, it might be that you are a company that's authorizing an international franchise. So if you're McDonald's and you want someone to open up a McDonald's in Paris, as one of our hypothetical situations earlier in the book sort of mentioned, then you want to have a contract with the person opening that McDonald's in Paris that might include specific things. Among those are going to be declarations of which forum you intend to use if there were ever to be a dispute about the contract itself, right? You can actually designate in your contract with whatever foreign entity that you're doing business with what you think should be the appropriate nature of how your dispute will be settled. So if you say that you expect it to be handled in a French court or in an American court, then courts might grant deference to that preference since it was agreed to by both parties. Or alternatively, if you don't want to have to worry in this contract relationship about actual formal litigation with the assistance of a government helping you make those determinations of who was right, who was wrong, then you can just agree to arbitration. And courts might find that to be binding as well. If someone tries to go and file a lawsuit instead of going through the agreed upon methods of arbitration, then a court might say, nope, that it was part of the contract. Both parties agreed that they would agree to a neutral arbiter designated in the contract. Okay. So if it's a contract for buying or selling, if it's a contract for a franchise, if it's a contract for marketing purposes, kind of like the hypothetical about the Jaws revenge that we were talking about, that was a hypothetical contract with foreign distributor, right? In all of those situations, you can specify in the contract language itself what you expect to be the method of conflict resolution. Let's talk about jurisdiction. Now, jurisdiction is important not in arbitration, but is important in actual litigation in a real court, not some type of neutral arbiter helping you decide right and wrong, but formal litigation. Jurisdiction is necessary for litigation. Jurisdiction is defined by both me and the book as the necessary ability of a court to hear a case. Okay. Where a court is competent to hear a case, it has the ability to control the parties, to issue a binding ruling, to determine if a party to a contract is at fault. A jurisdiction could also include criminal jurisdiction, such as the ability to determine whether or not criminal sanctions might apply to some type of act or conduct. And then finally, jurisdiction is the ability of a court to determine what remedies would most appropriately apply to someone's bad act. So if we're talking about a contract dispute, then the court would help the parties determine what the bad actor would have to do in order to fix their pre-existing bad act. So let's say it's an agreement that you're an American and you send a product to Mexico for them to sell it in a marketplace, and then they'll send you some of the profit, right? So that you make money off of the relationship and they do too. But let's say, okay, they took delivery of the product and they did sell it in the Mexican marketplace, but what they failed to do is send you your cut, okay? They failed to send you your check. So you go sue them. Okay, there are many possible places you might sue them if you didn't specify already in the contract. Maybe you'll sue them in Mexico because that's where they're at. So that would make a lot of sense, right? To go ahead and sue them in a Mexican court. Well, that Mexican court that has jurisdiction over that case, because they have the ability to hear the case, they're competent over the case, they have personal jurisdiction over the parties, and we'll talk about that a little bit more in a second. That court gets to decide what that Mexican distributor of your product has to do in order to make up for that breach of contract. They failed to send you your cut, failed to send you your appropriately designated check for some of the profits of those sales. So they might have a menu of options, right? That Mexican court could grant a injunction saying, well, this entity is no longer allowed to do business until they pay their debts. That might be fair. They could grant a reward of monetary damages, saying the defending party is required to pay the American seller of the product. They could also require that they pay interest or some kind of additional penalty, right? Some kind of restitution. What if that money that failed to be delivered back to the seller in terms of profit could have been invested over that amount of time and made a little bit of dividends? Well, maybe that penalty isn't just going to be for the profit lost, but also a little bit more to make up for the fact that there were some damages there, right? The company couldn't reinvest their money to go sell more in other marketplaces. So that's the basics of what jurisdiction is. In terms of getting it, in terms of finding jurisdiction and getting appropriate jurisdiction, we have a lot of layers of complexity. Let's talk first about territorial jurisdiction. Territorial jurisdiction is the power specifically of criminal courts to hear cases involving crimes within their geographically defined territory. Okay, so obviously, let's use an example. In Durant, Oklahoma, which might not be the location of many of the folks taking this online class, but assume that you're in Durant, Oklahoma. Who has territorial or criminal jurisdiction over our geographic region? Okay, well, we have some overlapping jurisdictional abilities here. A state court located in the county of Bryan County would have some territorial jurisdiction, almost certainly because Durant's located in Bryan County. Okay, and criminal jurisdiction is one of the powers granted to that state court by the state. But you might also have, because we have a system of federalism in the United States and we don't just have a state government, right? You might also have the jurisdiction of another court, a federal court on the national level, having territorial jurisdiction over Durant. And in fact, they do. Oklahoma is divided into 3 geographic regions with 3 different federal courthouses. One of them happens to be in Muskogee and covers most of eastern Oklahoma. There's another court in Oklahoma City, and there's another court in Tulsa. So depending on where you are in Oklahoma, a different federal court might have territorial jurisdiction geographically defined over a certain area. If you committed a federal crime in Oklahoma, then the federal court for the Eastern District of Oklahoma in Muskogee might be the appropriate location for your criminal prosecution. Okay, so that's territorial jurisdiction. In rem jurisdiction is the court's power over property within its territorial boundaries. So a court might have power not just over individual humans, but also over property such as roads, bridges, waterways, and canals within a certain territory. So if something took place that involved one of those physical objects, a dispute over the rights to navigate a river, let's say, then a court might have in rem jurisdiction, territorially based, because it happens to exist within that court's territorial boundaries. Okay. Finally, subject matter jurisdiction. Subject matter jurisdiction is pretty common in the United States, although not every court in every country decides that they want to split courts up based on the topic discussed. Okay, in a lot of countries, especially less developed countries, their governmental courts might hear any type of case. They could hear a criminal case, they could hear a civil lawsuit for damages, a contract dispute, custody for kids. They might hear a tax case. Okay. In the United States, we have a trend towards splitting up courts based on subject matter, at least a little bit. Okay, most state courts don't have too much limited subject matter jurisdiction. They can hear almost anything. Bryan County Courthouse, you're going to see people going in there for contract disputes, criminal prosecutions, custody battles, divorces, marriages, all types of things. But on the federal level, we have some courts with subject matter jurisdiction. For example, we have specific courts for bankruptcy. Okay, we have specific courts for tax law in some cases. And there might even be specific courts for certain administrative law matters. For the most part, when we're talking about the types of business transactions that this class covers, most courts are going to have general subject matter jurisdiction over almost all disputes. So for the most part, subject matter jurisdiction isn't going to be an issue for the information in this class. But it's something to keep in mind. If you're doing business in a foreign country, take a look at their court structure. See if the courts are divided up based on subject matter or based on geographic lines. and see what types of appeal options there are. It might turn out that, like in the United States, in the federal system, we have several levels of appeal. You might start out at the district court level. I mentioned, for example, the district court that covers our region is the Eastern District of Oklahoma, located in Muskogee. But if you lose your case in that court, you might ask the next level of courts to hear your appeal, right? To hear your argument that the lower court got it wrong and that you were right. The next appropriate level for you to go to in our region is the 10th U.S. Circuit Court of Appeals, which is actually located in Denver, Colorado, because the 10th U.S. Circuit Court of Appeals is geographically defined, covering a whole 5-state area here in the middle of the country. And then, of course, the third level would be to appeal to the United States Supreme Court. So we know from our system that we have 3 levels of appeal. Other countries might also have levels of appeal, right? And that makes all of this relatively complex, and it can drag litigation on and on for years, which is why I think your book sort of implies at best that it's usually best when you're making contracts with foreign entities to designate arbitration, okay? Designate arbitration as your preferred method of alternative dispute resolution, as opposed to going through the normal litigation process. It will be quicker, it might very well be less expensive, and you won't have to worry about all the different levels of appeal that could drag your case on and on and on. Also, you have less worries about jurisdictional issues, right? So when you pass this class and you have your business degree and you're out in the world advising companies on what best they should do in these situations, you can definitely consider it the advice of this instructor as well as your textbook, that alternative dispute resolution is far more preferred to direct litigation, okay? Let's continue. In personam jurisdiction. In personam jurisdiction, and all of these, in rem, in personam, these are all Latin phrases because we borrow a lot from Latin to we create part of our legal language, part of our medical language, our scientific language. A lot of the root words come from Latin origins. In personam jurisdiction is the power of a court over a person, okay? A person, for that definition, could include a business entity, okay? A corporation could be considered a person for the purposes of lawsuits. A corporation existing within the territorial jurisdiction of a court, that court would have in personam jurisdiction over them. You have to have personal jurisdiction, in personam jurisdiction, to hear a case. It's part of the necessary requirements for a court if they're going to hear a case. Now, the question is, who decides whether a court has this jurisdiction? Almost all of the time, the answer is the court itself. The court will take a look at the facts of the case, the geographic locations of the parties, both the plaintiff and the respondent. They'll take a quick look at it just to see if they have jurisdiction. That's going to be the first thing that they do. And then they will declare whether or not they have jurisdiction over that case. They will decide whether or not to hear that case. Okay, so that's kind of an initial question for every single lawsuit ever filed. Does this court have jurisdiction? Is going to be the first question in the mind of every judge. Okay. Now, what does it take for a court to have personal jurisdiction over a person or a business entity? Well, obviously, being located within the jurisdiction might have some relevance, especially if you live there. The book uses the word domiciled. If you specifically look at one of the sections in jurisdiction over the EU, as I was reading that, I was wondering if everyone would understand what domicile means, because it's just an ancient word that means where you live. Okay, so if you live in Bryan County, it's pretty much assured that the Bryan County State Court will have in personam jurisdiction over you for any number of bad acts, right? Well, you could also have in personam jurisdiction over someone who doesn't actually live in a physical area. They could visit, Usually visiting isn't enough, but you could say, for example, if you're driving on the highways in Texas, even though you are an Oklahoman, that you have at least implied that you consent to their jurisdiction over, say, for example, breaking a very normal traffic law. Okay. You implied your consent just by being there and driving on those roads. So if you ran a red light and caused someone's injury, and Texas wants to prosecute you for running that red light recklessly, then they may very well be able to do that because they'll have personal jurisdiction over you because you impliedly consented by doing something. We call this concept minimum contacts. The idea that it's not okay to just be present, but that you have to actually be doing something. So if you are in a jet airliner flying over the state of Louisiana, it's probably unlikely that the state of Louisiana has actual in personam jurisdiction over you. You haven't really consented to their rules of particularly anything. It just happens to be where you are on your flight. Okay? So sometimes it gets kind of interesting when someone wants to sue someone for a bad act that took place in the air on an airliner over a certain jurisdiction, and they want to sue them in that jurisdiction that they technically never set foot in. They just existed in the airspace over. Okay. Um, this is the concept of implied consent. Okay. Minimum contacts usually means, do you do business there? Have you advertised there? Have you held yourself out as someone who at least exists there, even if you don't live there, by making a contract there? Some of the questions asked by the book are: did you send people there in order to negotiate a contract? Okay, so all of these types of things might create enough minimum contacts for a court to declare that they do have an in personam jurisdiction over you and can hold you accountable in that court for your bad acts. It is generally not considered fair to force a person to come to a place that's foreign to them unless they have at least established those minimum requirements. Among those requirements, this last little part of in personam jurisdiction, among those requirements to assert that control is what we call service of process. Now, service of process, you might see it in television or the movies, is where a person will walk up to you with papers in their hand. This is kind of the traditional method. There are many methods. Traditional method, you walk up to a person with papers in your hands, and what they are court documents showing that you are being sued in a court listed on those documents. And you have to physically put it in that person's hands. And as soon as that person grabs those documents, the law says that they have been served process. They have been properly notified of a pending lawsuit against them. And now that they've been notified, they can prepare, say, for example, hire their own attorney to prepare their defense. Okay. So service of process is a very normal legal tool that gives fairness to a person accused. It is not fair for you to not know that you are being sued, right? It is not fair for you to not have enough time to prepare your defense for a prosecution that may or may not be just, right? May or may not be correct. You may or may not have violated a contract, right? So that service of process, and this is generally required in every jurisdiction, in every court globally. Okay, this is not just an American rule. Service of process is a basic legal requirement that you must be properly notified. And until service of process takes place, the court cannot assert their in personam jurisdiction over you. Let's talk about some specifics of service of process. The example I gave you will almost always work for service. Sometimes the court will send their own person, a court clerk or a court marshal, to serve process. It can be kind of tense or anxious. A lot of times they'll hire some college student to go do it. Now they've got to go walk up the front steps to someone's house and say, your wife wants to divorce you. Here's the papers, right? That's service of process. It can be intimidating to some people because people don't want to receive service of process. It means something bad's happening to them. Um, and that's the classic example. Service of process in some jurisdictions is said to be sufficient if you send a certified letter with a read receipt that gets sent back so you have proof that they actually received the letter. Service of process in some states requires actual hand delivery. So you would actually have to physically hand the papers. The question is, what if they say, no, 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 I'm not grabbing that? Okay. A lot of times the court will say the attempt is sufficient. So if you can prove that you tried to put the papers in their hands, tried to hand them to them, then that's sufficient for service of process. Some courts have ruled that throwing the papers at them is sufficient, or placing them under their windshield wiper while they were present, kind of forcing them to see those documents and see that they've been sued is usually sufficient. There are jurisdictions where you have to have personal service. In other words, jurisdictions where mailing it to them is not sufficient. Your book actually does list some countries by name. For example, Germany, Norway, Egypt, China do not permit service of process with that read receipt through the mail. So you have to do your research. You have to go or ask your attorney, but you have to go and find the law on the books in the country where you're wanting to serve process, because each jurisdiction might have different specific rules. Okay. And for international service of process, there's usually one last option, usually the best option, and it's called a letter rogatory. Once again, the root's a Latin phrase, but a letter rogatory is a letter that's sent by the country of the person suing to the country of the person being sued, asking the second country, hey, will you please go send someone to issue service of process to our defendant? And the problem with that is it requires a bureaucracy to take action. So it can be slow. There might not ever be any direct proof that service of process took place, or if there is, it might be slow in being delivered back to the host country. So a letter rogatory generally is really good because you can eventually prove to a court that you both sent a letter rogatory and that service of process took place. But the slowness of the process and the bureaucratic situation at stake sometimes makes that less useful. A lot of individuals will not rely on the government to do their service of process for them because they see it as more useful to hire a private process server. Some people make this a living. Their whole job is to take papers and deliver them to people, or to find people so that they can find a way to deliver papers to them and serve them process. Okay. Let's talk about venue for a second. A court might have jurisdiction, but when we're talking about venue, there might be a number of different courts that have jurisdiction. And so the question of venue is, if you have multiple courts with jurisdiction, which court do you go to? Okay. In the United States, for example, if let's say, for example, I rear-ended another car, and as a result of my negligent driving, the occupants in the car in front of me received some injuries. And they want to sue me for those injuries because they're going to have medical bills. And they might have to call their insurance. They might have to go to the hospital. They might have to call an ambulance. Okay. Well, I owe them something because my negligent driving caused their injuries. They might have some options. They might be able to sue me in multiple locations. They could sue me where I live because there's some minimum contacts there. They could sue me where they live. They could sue me in the jurisdiction where the car crash took place. They might be able to choose whether to sue me in state or federal court, depending on whether the amount in controversy is more than $25,000 and if we're people from different states. If you satisfy both of those requirements, you might have federal jurisdiction because it's an interstate conflict. Okay, um, so the question of venue is going to be important. If you are writing contracts for a company doing international business, one of the things you want to specify, if you're not going through alternative dispute resolution, but you've chosen normal litigation, you want to agree with the other contracting party, not just which court you think has jurisdiction, but specifically which level of court or which venue. Okay. Out of the many courts that might have jurisdiction, which one specifically will you file at? Which one do you agree that you will send your attorneys to? Okay. And then the last concept here is forum nonconvenience. There's a really good hypothetical that's mentioned in your book that I want to note. And the hypothetical has to do with a plane crash. Okay. Let's say that there's an airline disaster, and this is mentioned on page 68 if you want to follow along there. There's an airline disaster. Now, in an airline, let's say there's 100 passengers on the plane. They're all from different places. Okay, some of them are from Florida, some from California, some from Canada, some from Mexico. And the plane goes down in North Dakota. Okay, a lot of those individuals on that plane might want to sue the airline. Okay. Jurisdiction might be proper in any number of locations. It could be proper, for example, where the airline has incorporated itself. If it's American Airlines, I don't know where their headquarters is, but wherever their headquarters is, okay, that would be one option. You might be able to prosecute them at the location of the defendant, where their home is, okay. But obviously, the most logical location to have that lawsuit would be in the jurisdiction where the crash took place. Okay, forum nonconvenience is the ability of a court to refuse to hear a case, even though they agree. They have territorial jurisdiction, in rem jurisdiction, personal jurisdiction. They checked off all the boxes. They have everything necessary to hear this case and to have competency to both decide who's at fault, to decide what the appropriate remedies are, all of those things. But they still will not hear the case because, in the opinion of that court, there is a better situated court to hear the case. Okay. So if one of the people on that jet airliner decided, okay, well, I found out that the airline's incorporated in Denver, Colorado, I'm going to file my lawsuit there. That court in Denver, Colorado may very well say, no, the crash took place in North Dakota. So you're going to go file your court case there. Okay. That's where the evidence is. That's where the people are that might be witnesses. That's the most logical place that will be able to exercise authority over that evidence and control it to some extent so that you can get to the root of the answer quicker, better, easier, more efficiently. Okay? So hopefully that sort of mini lecture over jurisdiction is helpful to you. Go ahead and start working on your discussion board post, and I'll lecture again on Thursday so that you can start working on your one-page response paper. One note about your discussion board posts is I've noticed that they're a little bit short, and I did encourage making more than one post. So you make your initial post, and that's what allows you to see the rest of the discussion board post by everyone else. I'm encouraging you to take the effort to respond to at least one other person's discussion board post. So in terms of each week, you should have at least 2 posts, okay? Even more would increase your chances of a higher grade, right? Take a look at your grades from the first one if you need to see how well you're doing, right? But I would encourage you to put a little bit more thought into the discussion board posts and to respond to at least one other person's post. Maybe you could say that you agree with them, you disagree with them for specific reasons. Always keep it civil, and always try and bring up new ideas, okay? Thank you.